Good afternoon. Welcome to Venable and our program today entitled Top 10 Tips for Nonprofits When Procuring Technology Solutions. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. And welcome to the pretty packed room we have here in Washington, D.C., joining us in our D.C. offices for lunch today, and to the crowd of 250 plus that are joining us on our video webinar across the country today. Welcome to all of you. As many of you know, these programs are recorded. The recording will be available tomorrow on Venable's nonprofit YouTube channel. All of you tomorrow will receive an email that contains a link to the video recording along with the PowerPoint slides from today's presentation, as well as full speaker bios. Those of you in the room today have a printed booklet that has a copy of our PowerPoint slides along with our full speaker bios as well. And those of you in the webinar, the email confirmation you received did contain a link to the PowerPoint slides. Today's topic, as many of you know, for the last 6+ years, we've been doing these monthly programs on a wide variety of different nonprofit legal topics. And what we try to do is cover kind of the wide range of legal issues that affect and challenge nonprofits on a daily basis. This is one of those areas where actually, I remember when I first joined Venable about 18 years ago. I came from a small firm where I'd started for a few years, and I was doing most of the work for all of my clients myself. But one of the areas I really struggled with was technology-related contracts. And for someone that doesn't have a technology background like myself, I realized that the contracts were a bit too sophisticated for my level of experience. And one of the things that attracted me about coming here to Venable, among many other things, was the ability to tap into a depth of experience and expertise in certain areas that I just didn't have myself or that my prior firm didn't have. And this is certainly one of those major areas. And I've been very privileged for the last 18 years that I've been here, and probably for the last 15, to work with my colleague AJ Zatola, who's on the panel today, who's really been our go-to guru when it comes to technology-related contracts and transactions and other ventures for our nonprofit clients. You are very fortunate to benefit from his wisdom and from the wisdom of the two associates, Chris Kim and Allison Laubach, are on the panel today, who have really had the privilege of being mentored by AJ over the last few years. And you're going to really benefit from a lot of very, very practical and important tips and knowledge and other practical guidance in today's program. For those of you in the trade and professional association community, these programs are eligible for CAE continuing education credit. Here is a preview of our upcoming programs. Next month, November 15th, our program is entitled Key Safety and Security, both Physical and Financial Risk Management Strategies for U.S.-based nonprofits operating overseas. December 5th, our program is entitled Performance Management, Getting the Best Out of Your Nonprofit's Workforce. Starting next year, January 18th, our program is entitled The Top Privacy and Data Security Trends and Issues for Nonprofits in 2018. And on February 15th, our program is entitled Nonprofit Mergers, Alliances, and Joint Ventures, Options, Best Practices, and Practical Tips. We have a really terrific array of upcoming programs, and I hope you'll be able to participate in those. A few comments about our speakers today, and then I'm going to turn things over. But one housekeeping tip. For those of you in the room, feel free to ask questions throughout the program. Just do me a favor and raise your hand and wait until one of the two microphones comes to you so that everyone on the webinar can hear your questions. And those of you on the webinar, please pose your questions to me using the chat feature on the webinar software, and I will pose those questions to our speakers at the appropriate times. Now, as I mentioned, to my far left is my colleague and partner, AJ Zatola. AJ and I have worked together for most of my time here at the firm. He is an absolute guru when it comes to anything related to technology-related contracts and all of the legal issues that go into that, the contract law issues, the intellectual property issues, the privacy issues, the defamation issues, business torts, anything and everything in between. AJ has a wealth of practical experience. He lives and breathes in the trenches of technology transactions for both our nonprofit and for-profit clients, and there's really no aspect of today's program that he's not intimately familiar with, and you're really going to benefit from his wisdom and insights here today. To AJ's right is our colleague Chris Kim. Chris is an associate in Venable's Intellectual Property Transactions Group. His practice focuses on assisting clients with intellectual property and technology transactions across a wide variety of industries. And to my immediate left is Allison Laubach. Allison is also an associate in the firm's intellectual property transactions group, focusing on intellectual property and technology transactions across a wide variety of industries. Their full bios are in your handout booklets in front of you. So without any further ado, I'm going to turn it over to AJ to get us started. AJ?
Great. Thank you, and welcome, everyone. Good afternoon. We're excited to have you here. We're going to try and make this discussion as lively as we can. I know information technology procurement doesn't exactly sound like an exciting topic, but today, because it's National Taco Day, we're not only going to give you 10 tips, we're going to give you bonus tips, too. So this is a very practical discussion, and in this particular case, I'm going to articulate a little bit about how we decided to break this down for you. We chose the term information technology to really try and capture broadly data, equipment, technology, and related services that all nonprofits utilize and that all nonprofits, frankly, rely upon these days, much like their for-profit counterparts. Also, we're talking about procurement situations. So some nonprofits may actually be in the business or as a part of their operations providing these kind of resources. But today's focus is on procurement, and certainly if you have questions about providing something like this, we can certainly answer those as well. Our practice covers both those who provide IT and those who receive it, but the focus of this discussion is on procurement scenarios. And what we're going to do is try and make some broad generalizations of the critical elements of a procurement arrangement that you should be focusing on. And I think it's important to emphasize that although this is a legal-based discussion, a number of these points are very important to other aspects of the nonprofit operations. There are business aspects here, there are costs, expenses, there are IT implications, obviously. There are operational concerns. These things can bleed into other areas such as HR. And so I really regard these kind of scenarios as best suited for more of a collaborative thinking than really just categorizing them solely as legal or even only IT situations. So when we say procurement, what do we really mean? It can mean a lot of different things for a nonprofit, some of which may never apply, but all of which we have encountered in our time representing nonprofits. And so we wanted to highlight some of these for you, which maybe you're not necessarily envisioning when you're thinking about what we mean by IT procurement. Mergers and acquisition transactions, yes, nonprofits can go through those. And as a part of those acquisitions of larger enterprises, IT is among the assets being acquired. Clearly, licenses are things you might typically think of, but it's rare these days for something to just be named an IT license. And so you're going to have to become familiar with recognizing agreements that involve information technology without the benefit of a title telling you that that's exactly what it's for. And so oftentimes you're going to see situations where the license or the agreement accounts for the provision of a couple of different things, namely information technology equipment or software, services, and other elements of this that generally tend to include a lot of data these days. Your IT may mean that you already have equipment, but you're receiving services, or that you simply are focused on managing data. Development arrangements. We do work on a number of those where you are either configuring something for your operations or you're involved in creating something new. Outsourcing arrangements, I think these days we're seeing less of those because human capital is being replaced by automation, and what used to be done by a room full of people is now being done by a computer. So what you might have considered to be an outsourcing arrangement in the past, these days it's more likely to be provided to you as a type of form of information technology. We're going to bring you through some terms that you may or may not be familiar with: software as a service, cloud computing. And then, again, ultimately, these things may be presented to you in combination. And unfortunately, the vendors do not typically use a lot of standard terms to identify all of these things that you're making or paying quite a bit of money for. And so we'll do our best to sort of break down the elements for you that, again, you really ought to be thinking about both as a part of selection, procurement, negotiation, budgeting, defining the scope of what you need, And from there, we're happy to take questions as we go along because there's no one-size-fits-all deal here, and people have different ways they go about procurement. So it'd actually be probably helpful for others to hear how your thought process might mesh with what we're explaining. So I'm going to turn this over to Allison to begin to introduce sort of the two traditional forms of procurement that we see on the software front.
All right. Hello, everyone. Can everyone hear me all right? I'm not quite as loud as AJ is, so I just want to make sure that the microphone's working. Perfect.
Not many people are.
Not many people are. So thank you, Jeff, for having us here today, and thank you, everyone, for being here with us. As Jeff said, my name is Allison. I'm an associate here in the IP Transactions Group, and I'm going to be talking to you a little bit today about IT procurement contracts. So as AJ said, I'm going to highlight really quickly two major ways of procuring software. First, you have the traditional... also have the slide clicker. So we have traditional software development arrangements where the software is being developed primarily for installation on your device as the client. This might involve some sort of full or partial transfer of ownership to you, particularly if what is being provided to you is being specifically developed or customized for you. You might remember back in the day when you were receiving software and you would receive a floppy disk or a CD, and you would take that and you would have it with you, and you would actually manually download the software. That's not really the case anymore today. With these traditional software development arrangements, a lot of vendors would also put their software in escrow, meaning they would give it to a third-party escrow agent for release upon certain conditions, such as vendor insolvency or a major services failure. So what we're actually seeing more and more of today is license-based IT services. One major classification is software as a service, cloud-based services. And here the software is not being hosted by you as the client or the customer, it's being hosted by the vendor externally. One of the reasons we're seeing more and more of this today is it's actually very pro-vendor. The vendor doesn't have to give you as many rights to their software. They're maintaining these rights and really just giving you the ability to access and use it. So AJ mentioned that there's no such thing as a one-size-fits-all contract. So sort of in that same vein, you should forget the idea that there's a standard contract in the IT industry. Even if two vendors are providing the same types of services or products to you, they might have different ideas about how they're providing these products and services and really what their obligations are. That said, a lot of vendors do have form contracts. So if you're going with them, they might present a contract to you that they tout as their standard. What you should really be aware of is that these so-called standard contracts are usually very pro-vendor. It makes sense when you think about it. The vendors are writing the contracts, and so obviously they're going to want to include provisions that are very favorable to them. So when you see these forms, know that it's really just a starting point for your negotiations. One thing to be really careful of is vague descriptions, particularly when it comes to service descriptions. If you've been negotiating with the vendor and they've made you promises in their sales pitch, or even as you're negotiating the contract itself, the vendor is only going to be obligated to what you actually put in the contract itself. So make sure you're really holding the vendor to what they promised you and really being as specific as possible in your service descriptions.
I want to add in one point here about the contract package you're going to encounter as well. It's unusual now for a standard single form to be used. You need to start visualizing your contract as encompassing an invoice or an order with a set of terms and conditions, along with terms governing usage, would now tend to be online. But taken together, this can be your contract package, and among the things that legal counsel can assist with is trying to ensure that the superseding terms show up in the governing document, where you may not necessarily have an opportunity to change an online form. We may be able to make adjustments to the overall contract through some other documentation.
All right, thank you, AJ. Okay, so here we have a list of different provisions that you should take into consideration when you're engaging in an IT procurement contract. This list isn't exhaustive, and it's not meant to be overwhelming or intimidating. It's just here to show you that procuring IT can be a really big undertaking. Our hope here today over the next hour or so is to talk you through some of these key provisions so you have the confidence to really know what to look out for when you're going through this process later on your own. So as with any negotiation, preparation is key. This is no different for IT contracts. Something you really want to think about is creating a multidisciplinary team. It goes without saying that your legal team is going to negotiate your legal terms and your business team is going to negotiate your business terms. But as Jeff actually alluded to when he was making his opening remarks, these contracts can be very technical and very complicated. And if you have designated IT personnel at your organization, their input can be really invaluable for you. They can make sure that you're really understanding the nuts and bolts of the services being provided and really help you to understand and make sure that what you're getting is what really is best for your organization. Also, competition is going to lead to better and faster results, and you shouldn't choose a vendor until the contract is fully negotiated. A lot of your leverage in these contracts and these contract negotiations is going to come from your ability to walk away from the vendor. If a vendor knows that they're not the only organization you're looking for, you can you can use them to sort of negotiate off each other and really see if you can get the vendors to make some concessions that are more favorable to your organization. One more thing I want to touch on with regard to strategy is best price does not always equal best vendor. IT procurement contracts can get pricey, and it's very tempting to look at the price tag first, but there are a whole host of other issues that you need to take into consideration. So in that same vein, you want to make sure you're screening and assessing every vendor that you're looking at. You might have some bigger institutional vendors that you're looking at that are a little pricier, and they might be a little less willing to negotiate the terms of their initial form contracts. That said, you can rely upon their reputation within the industry and really feel comfortable that what they're providing to you is going to be valuable and helpful to your organization. On the other side, you might have smaller vendors that come to you and they might offer great prices and be more willing to negotiate and really customize the terms of the contract for your organization's needs. That's great if you can get it. You just want to make sure with these smaller vendors that you're really looking into their financial stability and their resources and determining if they have the experience to really follow through on their promises. Scheduling is important, again, in every contract, and particularly for IT engagements. If the contract is for something that's mission critical to your organization, or you need to make sure you have up and running by a certain time, you want to make sure that all of your employees at your organization understand that, particularly the people who are working on the contract negotiations. But you also want to make sure the vendor knows that as well. You want them to know that part of your selection process for the vendor is going to be dependent on their ability to meet your scheduling requirements. So the next point, as you can tell, is important. I put it in bold because I want everyone here to be aware that although bargaining power may vary, most vendors are willing to make at least some concessions to you. Bargaining power varies based on the size of your organization and the size of the organization that you're contracting with, but even the bigger vendors are willing to make at least some concessions if you're not afraid to ask for what you want. That said, you also want to maintain a good working relationship with them because even though you might be on opposing sides negotiating this contract for your IT solution, ultimately, if you choose the vendor, you're going to be working alongside them for the foreseeable future. And you want to make sure that you're maintaining a good, friendly, healthy working relationship with them. Some vendors also might provide you with a term sheet in advance of contract negotiations. This can be really helpful if the vendor has a very long form contract and you want an overview of what types of provisions are going to be in the contract or a list of key provisions. But there is a tendency to start to use term sheets for something that they're not, and they are not legally binding contracts. You want to make this distinction clear within your own team and with the vendor and not rely too heavily on the term sheet for negotiations. We really recommend that you start your negotiations from the contract itself because this is the legally binding document.
I want to add some practical color to what we just talked about in terms of other things to think about. So be aware that you have opportunities to make changes, but it may not necessarily be in the traditional way that you've done it in the past. What we've found is that giving yourself a little bit of runway on procurement gives you more opportunity to negotiate changes. And the more vendors that are under consideration, the better you are to play them off against each other. In the past, what would happen is a selection would be made. You'd send the contract to legal the night before it needed to get signed, say, hey, does this look okay? We cannot really help you anymore in those situations. We can inform you of issues associated with the contract, which are useful to know, and we're always happy to do that. But you're going to have more success in these situations if you give yourselves some time, because you need to understand that the person that you're talking to may not have authority to make changes, but if you give them time, they can go find it. You will be dealing sometimes with resellers who need to go back to the manufacturer. You may be dealing with salespeople who need to go to other departments to get approvals for changes, etc. So give yourself some time, have a couple options. I'm going to let you in on a trade secret too. Be aware of the calendar. A lot of the sales teams are very motivated by their fiscal calendar, whether that be the end of a quarter or end of the year. You will get increased pressure if it's at the end of their calendar when they want to book the revenue. You will get things like, hey, I'll give you this much off if you sign today. Understand that all those things can be ignored, but they also can be used to your advantage. And so if you give yourselves time to set this up, and you're aware of some of those constraints, such as whether or not something's actually going to fall at the end of a calendar quarter, you can sometimes use those things to your advantage as you're moving forward in the process.
All right. Thank you, AJ. So moving on to the next slide. AJ stole my thunder on this one a little bit. He mentioned it earlier. But one thing we're seeing more and more of today is electronic contracts. And within these electronic contracts, we're seeing a lot of hyperlinks. So a vendor might present a contract to you that looks like it's 2 or 3 pages long, very manageable. You've gone through it, negotiated with them for the terms in this contract. But there might be hyperlinks within this 2 or 3 page document to additional ancillary documents, such as privacy policies, security policies, maybe even some business terms. And you need to know that the terms of these ancillary documents are binding upon your organization, even though they might not be physically in front of you, they are in fact a part of the contract. So you really need to do the legwork and click through each of these hyperlinks, read through them, and make sure you agree with the terms. Something else that vendors might try to do is include a provision within these ancillary documents that gives them the right to make changes unilaterally. When you're negotiating a contract, you want the terms to be fully negotiated. You want the vendor to stick with what they promised you that they're going to do, and you don't want them to be able to make changes later. So you might have seen language in privacy policies or other similar documents that says, we reserve the right to make changes and will provide notice to you of any such changes. Really what they're saying is we can change this contract, we'll tell you about it when we do it, but you don't have any rights otherwise. You're expected to be following the new terms of our contract. So you can try to combat this in certain ways. You can include provisions close to the hyperlinks that state that any material changes to these ancillary documents will give you the right to terminate the contract, or even state that any changes that you're making in these ancillary documents must be mutually agreed upon, and if they're not mutually agreed upon, the terms of the contract that existed when you executed the contract will govern.
Something else to add as well, we are very thoughtful about costs associated with various IT products. Not all of these things are worth months of negotiation, particularly when you're getting some off-the-shelf product that might only cost you a nominal amount on an annualized basis. So we take that into consideration, we're evaluating. But occasionally, the cheap option is completely inappropriate for the usage. If you're going to store mission-critical information, you need to be more thoughtful now about going out and finding the free-based solution that doesn't provide you any assurances on security or give you access to your data. In addition to that, you need to be aware that everybody uses short order forms. That's typically not the contract. We received one yesterday of, hey, can you eyeball this 2-page form that cross-referenced to an online 30-plus page services document? that services document is something that we have to kind of work with. We may not necessarily implement negotiated changes like we've done in the past, but there are things we can bring into the process. And finally, be aware that sometimes it will cost you more. With these types of solutions that are becoming increasingly based on service models or the thought that you're actually remotely accessing something, understand that you're no longer paying to buy a lot of tangible equipment, and there's no need to install it, repair it, etc. And so there can be, and there should be, a major cost difference between some of these solutions that are cloud-based or software as a service-based. At the same time, it's also important to realize that some of these things still cost a tremendous amount of money, particularly those that have a lot of data storage attached to them. And so your cost here still needs to be assessed as you might have, but do appreciate that there's a spectrum. Some solutions simply cost less and you're going to get less, whereas others can be more configured or customized for your needs, and that can cost a lot more.
On the other side of entity size for vendors, one thing to think about too is this idea about adding links to external document is the bread and butter of the largest, most institutional business enterprise vendors. Nearly all of them are moving towards this model of maintaining an online contracts database that contains hundreds, if not thousands, of supplementary terms, each specific to their different products, and just referencing them to make their contract that they put in front of you that's negotiable look shorter. Very recently, I think it was 2 weeks ago, a client put a contract in front of me that looked great. I clicked on a couple of the links in the electronic form and discovered that literally 250 pages of external product supplementary documents and privacy policies applied to the contract. So needless to say, it was a fun night for me that day. But I had to tell the client that even though the contract looked good on the outside and the salesmen were pushing the simplicity of it, the truth was that they were just relying on people not doing their homework and customers not having the time to review these things. So please do be careful about that.
And sort of going off of that, one efficient and effective way that vendors are going to try to sort of get contracts by you is to have them drafted in a click wrap agreement. I'm sure you've probably all seen these. I myself write a lot of them, and they're seen a lot with terms of use on websites, et cetera. But there's a form contract, and you scroll through it, and at the very end, you're expected to click whether or not you agree or disagree with the terms. Very easy, very straightforward, but as you're reading these terms, really consider whether or not you'd be better off negotiating the contract yourself.
Before we move on from this slide, and this for any of the panelists, do you want to speak to a minute on the issue of electronic signatures? Because I know it's not a new issue, but it's an issue we constantly get questions about. Even yesterday, I negotiated a contract for a new CEO of one of our clients, and the attorney on the other side was asking for hard copy paper signatures in duplicate, and I thought I was like hearing something from 2 decades ago. But do you want to speak to that for a second, AJ?
Yeah, sure. So electronic contracts can be valid. What constitutes an electronic contract can vary, and what constitutes your signature can also vary. I tend to think about the electronic contract formation process as a process with several steps, but there are 3 things I look for which need to be recorded in some way. And if I don't see these things, then I can't really promise or assure anyone that a contract is valid and binding. But in particular, you're looking for some ability to review the applicable legal terms in advance. If you aren't given that, then you're starting to destroy the formation process a little bit. Second, you need to be presented with a choice. If you don't have some opportunity to say yes or no to something, or at least to understand that you're saying yes or no to something, then again, you also don't necessarily have a contract being formed where there's a meeting in the minds. And finally, and this is sort of the thing that people focus on, is that action that kind of shows your assent to terms. Now understand that in this setting, you're typically being presented terms and doing something to accept them or agree to them. Traditionally, we've used a signature for this, but in the past, there have been other forms to show that acceptance. The law will recognize a lot of different mechanisms for acceptance and signifying acceptance. Click wrap, clicking I agree. There's DocuSign. You can use your mouse to sign, but taken together, these are all actions constituting the act of saying, yes, I agree to those terms. But you need all three of these things for a contract to be valid. I would also add that for record-keeping purposes, it's very useful for both sides to have some record of what you just accepted and the date on which you agreed upon it. For me, I think these are more vendor issues than they are customer issues, because it's easier for the customer to say, I didn't know or I didn't have it. From my perspective, when I'm the vendor, I want to make sure that the client understands they just accepted a contract. And this is sort of the same as a traditional signature approach where you present copies to everyone on the date that you sign, sometimes countersigning 2 copies. When we do electronic contracts, I have a strong preference for making the terms that were just agreed upon available and providing some kind of date record that they were accepted on such and such date. So you could literally pull something out of the drawer or have some record that it was accepted or agreed upon. For your purposes, this is still useful because sometimes it's necessary to know when a contract started. Many of these terms are activated, so to speak, upon acceptance. And so when you're collecting documents, remember to collect not just the order or invoice, which will be what the sales team pushes, but the corresponding documents that go with it. And if you need assistance locating these things for some of the larger enterprise providers that don't like to make it easy to find the applicable terms, we can help you with that too. And we don't want to scare everybody by saying that you're going to be presented with pages and pages and pages of terms. Some of the larger contracts present all the available terms at once, as opposed to those applicable to your narrow selection. But among the things we can help you do is sort of identify which ones apply and whether or not what you're seeing is standard, because for a lot of these situations, there's a cost benefit to this approach of procurement that is cheaper than the older way of buying everything just for yourself. And we always like to emphasize that. In addition, some of the things where the contract might disclaim or limit liability may in fact be providing you more than you already have. So we appreciate that, and we're happy to kind of explain when things look reasonable or market standard as a part of this process.
All right, thank you. So we are actually now going to get into actual provisions within these contracts that you're going to want to consider. Term and termination provisions are important in every contract, and IT contracts are no exception. One thing AJ sort of alluded to earlier is that the duration of the agreement is not always the same as the duration of the services provided. Some vendors are going to put the full body of their contract into an agreement that they'll classify as the master services agreement, and the term might be longer. In some cases, the term might be in perpetuity, and then the services are going to be integrated by inclusion in separate ancillary documents like statements of work, and these service terms might be significantly shorter than the terms of the agreement. This can be really beneficial for you if you're thinking that you're going to be using this vendor for a lot of different services and you don't want to take the time to renegotiate the terms every single time you're getting a new service. On the other hand, it can be a little bit harmful if down the road you're looking to contract for something that's very, very different than the initial service that you contracted for, and perhaps these terms in the master services agreement aren't quite as favorable to you anymore. You also want to look at any renewal options that the vendor provides to you. A lot of vendors will try to include automatic renewal provisions, which means at the end of the term, the contract is going to renew automatically unless you provide notice otherwise. It's usually better for you to have to affirmatively agree to the renewal. Mistakes happen, accidents happen. You might miss the time frame for providing notice that you don't want to renew, and you don't want that to result in being required to stick with the vendor for another term, particularly if the term includes a price increase. So just be aware of that, and also know what notice requirements the vendor is going to give you. Are they going to provide you written notice when the term is ending? That sort of lays out your renewal options. And how far in advance of the end of the term are they going to do this? We also recommend laying out transition services. If you have used the vendor to provide you with something that's integral to your organization, maybe something like your payroll services, you don't want there to be a period of time when you're switching from one vendor to another vendor where your employees aren't receiving their paychecks. You want the transition to be as smooth as possible. And a lot of times there's an emotional component to this. If you're moving from one vendor to another vendor, you're essentially firing the vendor and moving to someone else who may or may not be their competitor, and they're not going to want to do anything more than what they're required to do. So just make sure you lay out those terms in advance. You also want to make sure you're getting back all of your data and confidential information. At the end of the term, you shouldn't be allowing the vendor to keep this. You want to explain that everything is coming back to you, and you want to set out a time frame for when that has to happen. Just to reiterate, long-term contracts and short-term contracts have different benefits and downfalls. For a longer-term contract, it might be more cost-effective because you're not renegotiating the contract as frequently, and you can lock yourself into price terms. But shorter-term contracts do offer you more flexibility with negotiation, so you really need to consider which one better fits the needs of your organization. Again, I spoke about this a little bit before, but I can't reiterate it enough. You want to be as specific as possible in your description of services. No matter what the vendor has promised to you, they're only obligated to perform what is set forth in the contract. So this is where it could be valuable, again, to have your IT personnel involved. They can really help you set the technical terms and make sure that you're really getting from the vendor what it is that you need. Again, these service descriptions might be integrated into the contract as a statement of work or order form. You want to make sure you're understanding what types of services are provided and really lay that out. And also consider including schedules, milestones, and timetables. This can be particularly important for longer-term engagements. For example, if the vendor is helping you with a major systems integration project that's taking place over the course of a year, you don't want to wait until month 11 to check in with that vendor and see how things are going. And you also don't want to give them any reason to procrastinate. So you can really set benchmarks for them and schedules to make sure they're on track and providing you what you need. Also, with deliverables from vendors, you want to know what role you're going to play in the review cycle. For example, if you're receiving a software application from the vendor, what role will you have in the testing process? And ultimately, will you have the ability to accept or reject the deliverable that's provided to you? If the deliverable does not meet your standards and you go through the acceptance process and you reject it, you want to know what the next steps are. Is the vendor going to reperform, or are you going to have the ability to terminate the contract? And the last thing I'm going to touch on really quickly before I hand the presentation over to Chris is different payment terms. You want the fees laid out in advance. You don't want any surprises later. But something else that's really important that you might not think about is contracting for robust invoicing requirements. Some vendors might try to give you an invoice that's not itemized, so you're not exactly clear on what it is that you're paying for. You obviously want to know how frequently you're receiving the invoice, so how often you're paying, how long you have to pay the invoice once you receive it, but you also want to make sure that it's itemized and you're making sure you're not paying for anything more than you should be paying. So with that, I'm going to hand this over to Chris to talk about. And
actually, Allison, before we move on, can you go backwards to the term and termination slide? Yes. Just one point I wanted to ask you guys about, to drill down on a little bit. You talked about a lot of aspects of term and termination, which are obviously critical points in any contract. There have been many times, as AJ knows, where I get an email from a client, saying we're having some real issues with this technology vendor and we really want to get out of this contract. First thing I always do is keep my fingers crossed that we were actually the ones to review the contract in the first place, because I know if it had this team's imprint on it, we're going to have a much better chance of being able to get the client out of it with as little pain as possible. But unfortunately, oftentimes that's not the case. You guys want to speak for a minute to kind of the issues that you've seen a lot when it comes to an unhappy relationship where the term has not expired on the contract, and the nonprofit wants to force its way out of the contractual relationship. Any tips, suggestions in terms of the types of termination provisions and things that you want to build into that to help protect the nonprofit?
So we started with these two slides because we really think they're the two most important things of a lot of modern IT procurement arrangements. How long it lasts, when can you exit, and what exactly are you paying for, how often are you paying? And we have found that when faced with a lot of standard terms, you are not typically going to get the benefit of a fully negotiated contract that gives you a lot of rights, recourses, or remedies under the standard legal terms. So what can you do? Frequently, the easiest thing to do is go find another vendor. This can be painful if not thought about in advance, but it often is the best recourse. And so as a general matter, we do not like long terms unless there is a substantial discount being offered for a longer duration. The longer term is supported with a services commitment that will enable you to have problems fixed, or you're dealing with something that is just simply difficult to transition. And believe me, this can be the case where it's simply too hard sometimes to move frequently from one vendor to another. But short of those situations, with a lot of standard off-the-shelf stuff that you might be procuring, if you can get it by the month, that'd be my preference, because leaving is the best way to motivate a service provider or vendor to do something for you that you're unhappy about, because a lot of times we're not going to have the benefit of the contract spelling out a remedy that you'd like to see. We used to be able to do that with customized software procurement where there was installation and an opportunity to test things in advance. But for stuff that you're simply going online to sign up for, receive, or turn on and off, you're not going to see that in the contract. But if the vendor realizes that you're not going to be there anymore because you're unhappy, many of these vendors will do things not stated in the agreement to make things right, to keep you as a customer. But a lot of that leverage comes from your termination clause or from your description of what you thought you were going to get in advance. And so we think that these are two critical parts of the process that will really benefit you in a lot of situations. We've got a question back here.
Brittany.
Hello, can you hear me? Okay, my name is Guillermo from CIO at NCARB. Thanks for all the great information. I have two questions, one related to what you're just saying right now about terms and terminations. There's been a big movement of a methodology in IT called Agile that has been taking the whole world by force, and that doesn't rely so much as before, especially when there's professional services involved in the contract, in terms of reference at the very front, because it understands that things will change. So the way that I've worked around those is by having a strong master service agreement and then having very short SOWs, statement of works, that allow me to contemplate changes in the requirements as we move forward and maintain a good relationship. Is there something else that I could be doing other than that?
So the question here is typically what kind of documentation would you have for an ongoing relationship, or what you can provide or receive or procure from a provider might be a number of different things. And you can see this often with vendors that are capable of giving you a lot, or even with resellers that can give you a lot of different products. You will typically have some kind of master level contract, which is important to understand that that kind of sets the general boundaries of the relationship. But in addition, there's nothing wrong with having other documents, statements of work, orders, et cetera, that will define particular engagements or particular relationships or particular fee obligations. Recall that we started with the term and termination clause, noting that the duration of your contract can be different than the duration of what you're paying for, duration of what you're receiving. And that kind of goes or plays into the idea that you're thinking of, where there's sort of an ongoing contract in place, which many vendors like, and frankly, a number of departments like, because there's no need to renegotiate with lawyers. But attached to that will be a number of order forms or documents can be important. They'll set the fees, they'll describe what it is you're receiving, they will have particular terms about how long it lasts. And so you need to kind of tie the two things together, and for the benefit of everyone in the room, you need to know that that underlying contract still applies.
And one last question. This one's for Allison. In the service description, the auto renewal actually touched me very closely because I had that problem as soon as I started at NCARB, and I couldn't get out of a bad relationship. What are your thoughts around including rebidding moments at the end of the contract term? Is that something? Is that a best practice where you are saying you're not only have to sit down again and renegotiate the renewal, but actually I'm going to make you bid for it again? I think there's a trade-off there where you've been working in a good relationship with them and you want to use that in your favor, but at the same time, you might be losing the opportunity of seeing other prices come through. So any thoughts on that?
I think that can be beneficial. I don't know, as you were talking, I could see Chris moving on his microphone to chime in. But I would say that it's beneficial to be able to renegotiate the terms, but also to sort of have a new bidding process. You don't want to alienate the vendor, but at the same time, if it's beneficial to you, I think that they're going to understand that. And as you said, if you've been burned by an auto renewal provision and you don't want to have to deal with that again, I would include as many outs as possible really for you at the end of the term.
A couple of things. I think that's really a practical consideration. I would highlight two major practical issues that's definitely suited for a joint discussion between the legal and the business teams. First is the nature of the services, right? If it's a service that is, as Allison alluded to, mission critical, heavily integrated into your organization, then getting bogged down in a rebid may not be the best choice because you're leaving a lot of your other departments high and dry in terms of the services that they need to receive day to day. But if you have flexibility there, then the other concern is time, right? I would love to have a new bidding process if you have the time to stage that bid, right? But you know from your prior experience, I'm sure many people here know that time is critical in the bidding process, and the vendors are well aware of that. So their receptiveness to that may be tied to their perception of how much time you'll really have to re-engage with other vendors who you remember you may or may not have rejected in the past the first time you signed the contract. So keeping a good measure of those two things on a case-by-case basis, I think on its face it's a great idea, but you need to temper that with your understanding of the other variables.
Thank you.
So with that, thanks again for Allison and AJ. We're going to move on to proprietary rights. And again, thanks to Jeff for his great introduction. But for those who don't remember from so long ago, I'm Chris Kim. I'm also an associate in the IP and Transactions group, and I work alongside Allison and AJ on these very issues. Proprietary rights, one thing we haven't yet talked about is ownership. And even if there isn't a contract provision that specifically titled intellectual property or proprietary rights, rest assured that ownership issues are lurking underneath the surface of almost all of the other substantive terms in the agreement, especially in IT, because these IT services vendors or product providers view the uniqueness of their proprietary tools or the exclusivity of the methods that they give to their clients as a core component, if not the sole most important component of the value that they provide in their sales. So they're going to be very jealous about drawing lines about their ownership of the things that they're bringing to the table, and you should be equally aware that you're often bringing pre-existing licenses or even owned IT assets as well. So making those boundaries clear at the beginning of your negotiation will go a long way in avoiding complicated default IP rules applying to your situation later, especially in the case of an assignment of a deliverable or a product that's being developed by the vendor according to your specifications. Even though they're selling it to you, so to speak, it's not like they're selling you a car or a house or a book. Traditional notions of proprietary rights and intellectual property don't always cleanly apply to things like software, or especially things like software as a service, which we mentioned before. And oftentimes the rules about property and ownership are creations of contract, because the default IP rules are either non-existent or so complicated and poorly construed for this context that nobody wants them to apply. So making that clear in your contract is really important. Understanding the licensing situation. We mentioned before in an earlier slide the license to the software, the old Microsoft Microsoft Office model where you got a CD and installed it. License to access, that's that software as a service idea, and then assignment when there's a deliverable or a product that you're out and out buying. But remember, especially in the software context, just because you've bought a component of IT doesn't mean that there isn't some underlying license supporting that. The developer will often have these tools that it wants to retain ownership of and hold on to, and understanding and navigating the license that you receive from them to use those tools as embodied in these products will help you to use them to their maximum effectiveness, especially if you're looking to resale or otherwise commercialize them. Another thing to think about are data, usage metrics, and financial information. We'll be going over data in a future slide, but keep in mind that ownership of data is, like I mentioned before, a complex thing legally, and you do not want the default rules in under U.S. law to apply to these data ownership rules. You really want to be firm about them in contracts because, frankly, the regulatory regime is constantly changing. There isn't a lot of statutes in the books about who owns data and how it's described, and understanding the ins and outs of how your contract will spell that out is very important. And I want to think about trademarks and marketing publicity. I know for the nonprofit sector, you guys have a different type of an organization than a for-profit corporation. You have a specific mission, and you're concerned about public relations. Well, you'll be surprised at how these vendors want to give themselves a lot of leeway, especially the smaller ones, to put your name in customer lists, to put your logo on their website, to market their association with you through this contract as a big part of their expertise in the industry. And if you don't want your name being or your brand being put out in these different ways, then you need to be on the lookout for these provisions, which will often be short in a form contract, will give them a very broad license to use your trademark or brand or IP, and will not have a lot of restrictions about what they can and can't use them in. In a worst case scenario, I've encountered provisions that actually make it mandatory for you to participate in testimonials and for you to participate in their marketing outreach efforts. So you'll get calls from marketing references, in theory, just because you signed a contract and didn't read this provision. So please be careful about that.
And one this corollary tip there, if you are perhaps generally inclined to allow the vendor to, in some ways, promote the fact that you're a customer of theirs, at least at a bare minimum built-in prior approval rights. So any and all uses of your name, your trademarks, or anything else recognizing you as a client has to be pre-approved by your nonprofit.
Definitely. And finally, third-party materials. Bear in mind that on the front end, this vendor that you're negotiating with may have a huge number of licenses to other IT products, tools, or even entire services or components of services that are provided by third parties that you're not contracting with. So please push for transparency, visibility, or at least identification of these third parties so you understand all of the different moving parts and the different entities that might be assuming liability or imposing liability on you.
Chris, I think you might have skipped over confidentiality.
Oh, excuse me. Yeah, confidentiality and non-disclosure, again, will merit its own slide. But when I get there, please keep these proprietary rights issues in mind, because confidential information is many things, but it's also an owned asset, and having a sense of the license structure there is really important. Going to take a quick sort of foray into a more specific type of provision, which is service levels. Service levels don't always apply to every type of IT procurement, but for the types that they do apply, they are extremely important. The importance of them, though, is often masked by the vendor, who will pretend that service level guarantees aren't really standard in the industry for certain types of products or services, even though it's incredibly important to include them in your order or directly in the body of the contract itself. So as much as you want to be friends and maintain a good working environment, please do not take the vendor's word for whether or not they should be making these guarantees for you. The answers will vary heavily, and also the nature of the guarantee. For those that aren't familiar, a service level guarantee or availability requirement is basically a promise that's spelled out in a complicated way, but it's a promise for them to maintain the service that they're allowing you to access up on their servers for a set period of time usually expressed as a subdivision of a month or other time period during the term of the agreement. So as you can tell, this is primarily of interest for any solution that is externally hosted. In the software as a service model, which Allison mentioned has become the predominant model among the major vendors, you're not hosting this software, so the responsibility, at least in theory, to keep this software up and running for you to access it falls on the vendor. I say in theory because the vendor will go out of their way to make sure they don't have any contractual responsibility to make it available to you. I've been in many situations where in their haste to sign a great price or to work with a vendor that had an excellent relationship with the marketing department or the business department, you discover after the fact that there's nothing in the contract that commits them to keeping services up for a set amount of time. And then I have to inform the client, unfortunately, that unless you're willing to call this a straight-up termination for breach, there's not a lot built into the contract to give you a credit, to give you a refund. So building that up, even though it can be painful, even though it has to involve your IT department and your business team has to be really aware of the different time measurements involved, doing this in advance is the pain associated with doing this in advance is nothing compared with the pain of discovering that they have no obligation to keep these services up for a set period of time. The other thing to think about on this is these 99%, 99.99%, there are big charts available online to tell you how much 99% of a month is in terms of hours. I will not bore you by putting that in front of you today, but do keep in mind, though, that even though 0.09% doesn't seem like a lot in a vacuum, when you're talking about 0.09% of the hours available in 3 years, you're talking about a lot of time. And they're going to want to carve out a lot of exceptions for themselves about the commitment that they are willing to make, if they're willing to make one at all. And finally, monitoring and reporting, the tools available for you to determine whether or not they're actually meeting up with this equipment, this commitment, and the equipment available to you to do that. A lot of the larger vendors will expressly include provisions in their contracts that forbid you from using third-party monitoring tools or your own monitoring tools and force you to take them at their word about the availability that they're providing to you. Please keep a lookout on that and advise your security department accordingly, your network security department accordingly. Data recovery is another thing, obviously most important when data is a part of the service. When you're transferring your sensitive proprietary data to their servers for processing or storage, please do, again, involve your IT department in this conversation. You want to know, is there redundancy from multiple locations, or are they keeping all this data, all the eggs in one basket, and if that server goes down, then everything is lost? Alternative method of access, same story with the web portal that you use or the software portal that you use to access software as a service, making sure there's more than one way so that you're not locked out if something goes wrong with the security credentials there. Incident reporting, similar to service levels, you need to know when something's happening to your data, and vendors will not always be forthcoming about that, especially if there are third parties doing the storage for them. And scheduled downtime notices, again, just goes back to the exceptions that they're carving out for themselves to this requirement. Well, at the minimum, you'll want to know when they're putting the servers down for maintenance to give yourself a plan and your business and IT departments an opportunity to plan accordingly.
Let me just interrupt to say that there will be a lot of fee differences here at what you're paying and getting. And you need to understand and appreciate that. Something that doesn't cost very much, it's not going to come with a lot of assurances. If you're using Google Mail, they're not going to promise that your email will be available. So just keep that in mind. It sort of is, you get what you pay for. Also, keep in mind that you may not necessarily be able to dictate these terms, but it is useful to know what they are. This is a great role for IT. There are standard practices for security. There are certifications available for certain industry standard practices. You have your IT folks available or use a consultant, but you're going to want them to evaluate. And for the larger providers out there, they may be giving you quite a bit, but it may not necessarily be reflected as a contract term. It may just simply be a policy that they provide. But you can rely upon some of those policy statements, certifications, for your own risk assessments, because as we encounter an increased instance of security breaches and data loss, this is going to start playing into your insurance. And they're going to start asking questions whether or not you ask these questions of your vendors or at least know what their practices are on this front.
Definitely good to keep in mind. So moving on to staffing and subcontracting, important in any consulting arrangement. You may be familiar in other contexts outside of technology, but it's particularly important in IT where you're not just talking about the particularities of the customer's business. You're talking about a complex IT solution that a fewer number of people may be qualified to advise on or to work with. Assignment of a project manager kind of goes to building the right team on your side that Allison talked about, but having this designated manager spelled out in the contract or an order form really helps with communication, communication about schedules, communication about disputes or potential disputes. Staff continuity, a special concern for nonprofits, I know, because again, you guys have a particular mission. You guys operate in industries that may be unfamiliar to the vendor, and having to explain that over and over again to a revolving door of new employees coming in from the, especially the larger vendors who will be replacing them several times if they can get away with it over the term of the engagement. But also, if you're not satisfied with the staff, if they can't really gel with your team or provide the services on the schedule that you anticipate, then you want to have certain restrictions on reassignment or the right to remove, things that you can negotiate for up front, no matter how big the entity. It is something worth considering. Non-compete or non-solicitation, don't be surprised when this becomes more of a sticking point in this context than it does in other services arrangements you may be familiar with. Non-compete or non-solicitation is always a tricky issue, but again, in IT services, these vendors will be viewing their professionals as having specialized expertise above and beyond the typical business consultant. Whether or not that's true, that is the perception. So they'll be surprisingly uncooperative about these types of provisions, as much as you might like to be able to solicit their employees at a future date.
Chris, before you move on, you want to just quickly explain the difference between a non-compete, non-competition provision and a non-solicitation provision?
Definitely, yeah, two different things, so don't want to gloss over that. Non-competition situation where the customer is looking to secure an exclusive arrangement with their vendor, or also it's a situation where the vendor is trying to make sure, so it can refer to one of two different things. The other situation is one where the vendor is trying to make sure that in the course of their providing these services to you or enabling you with these facilities, you don't someday become a competitor to them. So there's two sides to this provision, so to speak, and it seems like something silly and unimportant for a nonprofit that doesn't on its face seem like it would ever someday transform into an IT services vendor. And yet for long-term integrations, there's this persistent concern, especially for smaller vendors who may have seen their clients transform into self-sufficient entities that are capable of providing the service that they originally contracted for.
And I presume, too, it's important to make sure that you carefully read that non-compete clause and work it into a form where you can be comfortable that if and when you terminate the agreement, you're not locked out of other kind of competing service providers that you may need to turn to.
Yeah, and that goes back to the benefit to the vendor type of non-competition where you want to make sure. It actually also goes back to the transition services that Allison was discussing. The vendor would love to have you on the hook for beyond the term of the contract to make sure that you can only go to them or go to them first, whether it's exclusivity in a bidding arrangement, as our friend over here mentioned before, or exclusivity simply as the sole vendor who's capable of providing these services to you. And finally, non-solicitation, which is, again, when they're providing this personnel, they want to guard against you poaching their employees, so to speak, or them becoming so comfortable with you, especially when their boots are on the ground in your facilities, that you want to make them full-time, based on your long-term business goals. Contractors are very sensitive about that in this space.
And there's nothing wrong with making a non-solicitation provision mutual as well, correct? I mean, certainly we know a lot of our clients have some very talented technology staff that the vendors would love to poach for their own companies as well.
Absolutely true. And to the extent that contractors are being very intransigent about this provision, that is one thing to push for them, is to say, okay, well, then let's make it mutual. Let's make sure that you guys don't get your hands on our in-house IT professionals as well. Confidentiality is a big one in any IT services procurement because there's so much going on here that could be construed as confidential or proprietary information. There's the confidentiality of the things going on in your business and the things going on in the business of the vendor, but there's also confidentiality about the various tools and solutions involved. As I mentioned before, these IT services vendors view a big part of their value to customer as the exclusive or secret, trade secret, or even in some cases patented nature of the services, software, and products that they provide. And confidential information, a strong section here will go a long way in allaying those concerns on both sides. Defining confidential information is the first order of business. There's a large number of ways to do this, but they generally fall on a spectrum between a strict marking requirement, which is to just say it's not confidential information unless the communication actually says confidential or proprietary information directly on it, all the way to context of disclosure on the other end, which is sort of the parties generally understanding that based on the nature of the discussion, it should probably be created or treated as confidential, and everything in between. And then there are always exceptions to consider, things like material that falls into the public domain or different types of disclosures that didn't meet the standard that you build in there. The license to use confidential information is a part that's sadly missing from a lot of these provisions. Oftentimes the parties will just sort of trust each other to use confidential information confidentially and in furtherance of their obligations without actually saying that. And little do they know that the other party has a very, very different idea of what furtherance of performance means than, and so as with any type of license to any sort of property or intellectual property, being specific about the licensure can save you a lot of trouble in the future. Permitted disclosures, I actually want to tie this together with a bullet point that goes down later, the entity-specific confidentiality issues. So there's your standard permitted disclosures, which is when they get a subpoena, when the FBI is investigating them, and also disclosures to personnel and consultants. But I wanted to highlight, especially for people who operate in your space, the nonprofit space, your organization, based on its charter, based on its relationship with government entities, may have special administrative reporting requirements, statutory transparency, things that you need to share that vendors will not necessarily be familiar with. They're excited to have your business, but they're treating you as they would any other corporate client. So you need to be on offense here and provide them with any of these special reporting requirements that apply to your business, especially when it comes to the confidentiality section, because they won't necessarily be aware of the record-keeping particularities that apply to the organization, the nature of your mission, and it's your responsibility in a lot of times to inform them of that.
And for those of you that are federal or state grant and contract recipients, pay particular attention to this. It also plays into the proprietary rights section, and a lot of vendors are not going to be familiar with the rights of that federal or state government awardee under that contract or grant agreement. You need to be sure you're very cognizant of that when you're negotiating the agreement.
Two other points, because Chris is going to be leading us into data. First, you should always treat anything you're disclosing under these arrangements as confidential, even if it isn't. Members, donors, employees, I don't really care. Everything is confidential as far as you're concerned. And if your agreement does not account for confidentiality, and some of these vendor forms may not, it is perfectly acceptable to just use a standard NDA with the vendor. But you should always have something addressing confidentiality, because it's a great belt and suspenders approach to a big risk item now, which is data. Second thing on subcontracting is many of your service providers, software vendors, et cetera, they actually no longer host. And so there tends to be a separation now between who you consider to be your technology side provider, your software provider, and the entity that's actually responsible for hosting your data and what we're about to talk about next, which is security. And if nothing else in this process, if you discovered that split, that's useful to know, because some of these things are outside the control of your vendor, and you need to assess if you're comfortable with them utilizing a subcontractor. Now, many vendors do, so this isn't something you can avoid. But on occasion, you may also have an existing relationship with the host. There are some big entities out there that a lot of people use. Your standalone contract sometimes might be better than whatever it is they're providing or receiving. So keep in mind that just because you're dealing with a single entity, there could be a lot of people in the background that are providing all of this to you.
Definitely. Moving on then, as AJ mentioned, to the data portion here. Data is big issue. It's becoming bigger and bigger as the years go by. And one thing to keep in mind is that even if you're not necessarily contracting for what we call data services, data is always at issue in IT, or almost always. Your use of the service, your use of the software, your receipt of the product and enjoyment of it is generating data in some way in the IT space. And understanding the different types of ownership and the different relationships that are created by that data is really important, because it's a constant value concern for these vendors. Believe me, they're always looking for ways to market the data generated by their products and services, and whether or not you want to play that game is really up to the contract that you sign. So consider the role that data plays in this agreement. One helpful way to look at it is to think of things as quote-unquote data services, marketing, analytics, cloud storage, where data is a part of the product or service being provided. It's obvious then that data is at issue there, because you're giving them your data for them to do something with it. But also consider data about the services. Even if you're not openly providing them with data subject to a license in the contract as a part of the quote-unquote services, there are usage metrics. There are anonymized statistics being collected by your end users. Believe me, every single major IT services vendor has either a third party or they're doing it in-house. They're collecting metrics about how your end users are taking advantage of their services. And then also consider things that are specific to the way that the data is being manipulated by the vendors. Data hosting, storage, maintenance, access, and processing are all distinct ways of characterizing their use, what will be called a use and a license to this data, and knowing the difference and the different liabilities that apply to each is very important. When it comes to storage and maintenance, know where your data is being stored, where it travels. Make sure that you're notified if it's changed. Especially important for those of you who are part of nonprofits that are subject to special information requirements or limitations on storage overseas. It's not all of your organizations, but I'm sure some of you have run into those concerns, because the larger vendors will be storing the stuff overseas. They outsource it constantly just as a cost-saving measure, and you need to be aware of that and ask them about that so you don't walk into a regulatory violation by signing this contract. Vendors' security procedures are especially important. We'll be going over security in the next slide, so hold on to that one. Proprietary rights, as we went over before, always at issue, especially at issue in data, because as I mentioned earlier, data doesn't have a standard IP right that the U.S. federal law will kick in and provide to you or the vendor. It's largely a creature of contract under the current regime, which is constantly changing. Rights and access post-termination, going back to the termination discussion that we had. And again, actually, AJ already mentioned this. Hosting or processing by subcontractors. Basically, every vendor will be shopping this out somehow. They're not doing everything in-house in most cases. And knowing the identity of the subcontractors and the commitments that they've made with your data are, in many cases, equally important to knowing the commitments that are in front of you on paper.
Your organization's data is your responsibility. It doesn't matter if you're paying for someone else to be responsible for it. You're going to be deemed a steward, and so they will evaluate what steps you took to protect, or at least evaluate, the person who is handling and managing this data for you. Now, a lot of this is governed in the United States by a notion of reasonableness. So you can always assume that reasonableness will be attached to every consideration. If it didn't cost a lot or the data wasn't that important, they're not going to expect from you a standard of care that is much, much higher. But do appreciate that the responsibility rests with you, and in a sense, with these relationships, you're sort of appointing a steward acting on your behalf. So you at least need to think about these things. If you are presented with documentation saying, yes, I have security, meets these standards, to some extent, your inquiry is done. But you can't ignore these things any longer, because this is very much tied now to some of your major risk issues with your operations, and just simply assuming that it's the vendor's problem isn't going to work.
Right. The second part of this data component is privacy and data breach. Here we're talking about the worst case scenario, the negative side of what happens in the event of a data breach, and also what is your vendor doing to prevent that. Include language in the contract up front that vendor will comply with all data privacy laws, rules, and regulations, especially important because, as I mentioned before, the regulatory landscape is changing rapidly. And making your vendor assume the obligation to keep track of those things is a very important thing to explicitly include in your contract these days, now more so than ever. Personally identifiable information, a term many of you are probably already familiar with. which are different categories of information about individuals that can be used to identify them, things like their social security number, in some jurisdictions, their address. These have special rules and higher stakes, particularly in Europe and international jurisdictions. But honestly, even in the United States that has the global reputation of being a little lenient about these matters, you still can't avoid having to cleanse things with your privacy policy or making the right disclosures that have been imposed by the administrative agencies domestically. So please bear this in mind whenever you're dealing with data, that the laws vary wildly by jurisdiction. They're constantly changing, but there are some rules of thumb that you can follow. Reporting obligations and remedies in the event of security breach. This is another one of those things where the potential liabilities are so great that you need to spell this out in advance and do work with your IT department or your security consultants to make sure that you vetted these vendors. Oftentimes they'll be promising you a lot of great things in terms of sales, and they're making up those costs in infrastructure. And security, the quote-unquote industry standard concept may not always cut it here because, again, the industry in network security is very diverse, and standards are often hard to find, even though there are spelled-out standards that different governing bodies have promulgated. Think about a security breach versus a breach of contract and the indemnification obligations that go into that. A security breach, especially in the larger vendor contracts, won't always translate into a material breach of the agreement. And this goes back again to all of those external privacy policy documents, those different product specifications. The largest of the vendors will have crisscrossing disclaimers of liability in their supplementary documentation posted online that prevent them from, or rather prevent you from suing them or demanding indemnification for them for breaches that they consider minor but that you consider huge, because it's your personally identifiable information or the information of your members at stake. And they'll play the old card of saying our organization's too large, it's unrealistic for us to report this to all of our customers. So having that discussion again up front is extremely important. Considering cyber liability insurance is more just a transition to the next slide. So
before I move on, though, Chris, cannot stress how critically important this is. We get a call, unfortunately, probably once every few weeks, sometimes more so, from clients regarding the fact that they've had some kind of a data breach and want our assistance in helping to remediate it from a legal perspective. It is, and 99% of the time, it arises from a third-party vendor that was contracted under the principles we've been talking about here today. And so how you spell these things out in your agreements and what sort of obligation you put on the vendor and their obligation to cover your costs and all the reporting obligations and everything else, it's difficult, it's expensive, can obviously be hugely embarrassing. There's a lot of costs and burdens that flow from this, and so we can't stress enough how critical it is to try to shift some of those burdens onto the vendors to the extent possible.
Thanks, Jeff. Going on to insurance, we mentioned cyber liability insurance before. I know insurance is not the most thrilling subject in some circles, and it's definitely an interdisciplinary one because you need to involve your legal team in this, but also your risk management department if you have one, your insurer preferably, or an outside consultant who specializes in these matters. As much as insurance might seem like a laundry list, and I won't make you go through every single one of these different types of insurance, especially for those of you who are more familiar with these types than I am even. Knowing that insurance has huge practical relevance, especially in IT, because of the size of the vendors that are often pitching these services to you. The smaller vendors will promise you the world in terms of indemnification, in terms of the liabilities that they're willing to assume, but their business strategy is basically that if their indemnification obligations or liabilities exceed their insurance, then they're just going to go insolvent. And that's a part of their sales strategy, that they don't have the financial resources to deal with the massive amounts of liability that can arise from a security breach, that can arise from IP infringement indemnification. And being aware of that and making sure that you enforce fairly strict insurance obligations on them so that someone is able to cover the costs that are supposed to be allocated by your contract. Going to focus a little bit on this cyber liability insurance idea. Unlike the insurance that applies to general commercial contracting, this is specific to protection from costs arising from data security breaches, third-party claims, and Having, again, a joint network of your legal professional and your risk management professional review these things is important, because cyber liability insurance is much newer than the old professional liability, E&O, umbrella, laundry list. And for that reason alone, it's also generally more diverse. So one type of cyber liability insurance policy is not necessarily equivalent to another in this space, even though the vendors would often like to pretend that they are. Moving on from this slide to dispute resolution, go over this quickly. Just the practical point that we really wanted to draw out for dispute resolution is that IT services vendors and professionals will often want to have an extended period of time for informal dispute resolution, under the argument that because of the nature of the services that they're providing, the technological complexity of it, a lot of these things that would be cut and dry material breach or contract disputes are actually just misunderstandings between your engineers or your IT department and their technology professionals. Whether or not that's true, please do expect to see things that try to broaden the amount of time for informal discussions between your project managers, escalation. But do look out for maintaining certain remedies for yourself ahead of time, especially the withholding of payment. So many of these things are fee-based services with regular payments on invoices, and giving yourself the flexibility to pressure your vendors into compliance without threatening an outright breach of contract is paramount. Skipping down also to governing law and venue. Just one thing I wanted to keep in mind, the lawyers in the audience are well aware of this boilerplate stuff, but the world of acceptable governing law outside of the one that's preferable to your organization is a little smaller in IT services, because it's a newer field. So the commercial contracts bench is not as deep necessarily in some jurisdictions as others. So please be aware that you shouldn't just accept the vendor's home state offhand when it comes to this, because they may have a state law docket that's really dry when it comes to governing this type of transaction.
All dispute resolution processes are expensive. Remember that. There is no cheaper option. And frequently, the best course is just to exit and go find another vendor, even if you feel something has been performed incorrectly or not to the standard you were expecting. Just because no matter what happens, you're going to spend more money, time, and resources on disputing something than you really want to. So you need to be aware of what these are. You need to evaluate closely the periods or the ability of informal dispute resolution before you move to arbitration or litigation. But bear in mind that at the end of the day, I have found that usually the outcome is unsatisfactory. And so I wouldn't be hung up on these clauses too much. It's better to focus on being able to just simply exit.
Yeah, another great practical tip. Remedies and limitation of liability, the last of our major slides here. There's a lot. It's dense. It's very much a legal concern. Again, the lawyers know that this is often one of the most hotly debated provisions in any commercial contract. I wanted to focus your attention on particular types of liability here. Liquidated damages penalties are not necessarily common or standard, so please don't let a vendor convince you that they are. It's much more likely that they'll be focusing these caps on the services, fees, or permutations thereof. Injunctive relief, again, extremely important to secure for yourself this right when there's confidential information at play. So at least legally speaking, you have some recourse to demand the halt of a breach or a disclosure. Look at the direct damages limitation. IT vendors are very sensitive about this, and also when it comes to limitations on special, indirect, consequential, or punitive damages, bearing in mind that the one thing that's on everyone's mind here is intellectual property. Intellectual property infringement is the boogeyman of smaller vendors and large vendors alike in the IT space. They are terrified in many cases of your traditional IP patent troll claim coming and giving induced infringement claims against all of their customers, hiking up the costs to unimaginable heights far in excess of the value of any individual contract. So being careful about the claim limitations, things like limitations on the amount of time that you have to bring a claim under the contract or indemnification. These statutory or these statute of limitations created by contracts can really hamstring you, as well as exclusions to the limitation. Be aware that it will really be your responsibility to build in exclusions for indemnification, especially IP infringement, but also confidentiality breach, because remember, a lot of what we call damages, legally speaking, in terms of a breach of confidential information, aren't necessarily direct. It's difficult to construe them as direct damages in certain jurisdictions. So being careful to exclude this from the boilerplate special, indirect, consequential damages limit of liability is an important consideration to not limit yourself down the road. This last slide is a catch-all. Please don't feel the need to move through every point. But again, indemnification, we talked about reps and warranties. And I just want to stress one last time about intellectual property, especially with smaller vendors. If they are hesitant to provide you with the reps, warranties, and indemnification obligations that you need to demonstrate confidence in their ownership of their solution, that should be a red flag to you. Because whether they're just too scared of the indemnity obligations, or they have a reason to know that there's some sort of pending claim, or there's a major risk when it comes to the patent bench here with the services that they're providing, you should take that into consideration even over and above the cost. Because remember, the costs associated with IP infringement are almost, even if it's a throwaway claim, it's almost always greater than the costs associated with the actual services.
And just for those, I know we have a vast majority of non-lawyers in our audience today, just to make sure you understand the difference between a rep and warranty and indemnification. A representation and a warranty is basically, in this case, the vendor saying to you, we represent and warrant and attest to you that, you know, for instance, our software doesn't infringe anyone else's copyright, trademark, or patent rights. Indemnification is an obligation, say in the same example, on the vendor to indemnify, to protect you, the nonprofit organization, their client, in the event that something happens that they're responsible for. And of course, that Chris is talking about, the vendor is going to try to carve out as many things from that indemnification obligation as possible and try to limit it as much as possible. But the idea is that if they make a mistake, if something happens and you get harmed as a result, then they have to step in and protect you and pay your legal fees, pay costs of remediation, other things like that.
Exactly. Rather than going to the legal boilerplate at the end here, I think we wanted to leave some time open for questions. And I know we're running short, so maybe we can move to the final slide.
Chris, there's a question from one of our webinar participants who asked, Chris mentioned there's a limited number of jurisdictions that are appropriate for governing law and technology contracts. Can you list some favorable ones?
Sure. And here we're not necessarily looking at things that are favorable to the vendor or to the customer so much as simply jurisdictions that have an established or a growing body of case law. The primary ones that people will default to outside of their home states are Delaware and New York, and to a somewhat lesser extent, California. California has some weird law in other contexts, so contract-wise, you may not want to stick with that one, but Delaware and New York are the most commonly accepted default jurisdictions when you can't reach an agreement about your home states.
Any final questions here from the audience? Yeah, a couple questions in the middle of the room.
I just had a question. You mentioned the audit rights on that last slide and earlier talked about milestones. In regards to risk reviews and performance reviews, are you helping to draft clauses specifically to put those formal reviews in place for your clients?
We like to see them there. We may not necessarily be able to dictate what type of review is conducted, but as you know, there are particular standards that are provided for risk assurance and whether or not a risk assessment has been conducted that are generally recognized for your purposes as indicating that you evaluated that risk as well. So we like to see that, and that's something we very much think about when we're dealing with data and security now, is that those type of evaluations are being conducted, and I think you should be looking for those kind of things in your agreements. You may not see them with the newer guys, but it's something you ought to think about.
And then final question right here.
As the IT industry grows, we've seen a lot of takeovers where one company is bought out by another. And I'm just wondering, is there anything from a nonprofit standpoint we should be on the lookout for as we've used one vendor, their company's bought by another, and so on?
This happens a lot. The industry term for this is compliance. What happens is big guy buys small guy, and next thing you know, you're faced with a bill to pay a lot more. Ways to control this are very much tied to things we went over today, which is one, assessing how long something lasts, because those termination points, those renewal points, are where these new purchasers are going to present you either with new terms or new fees or new whatever. Second, the indemnification clause can be useful here because having that right to use what you already have a contract for can be very useful to confirm. Second is fees, again, somewhat tied into the service description or the term, but you want to have a sense of what everything costs, and you want to know what that fee enabled you to receive. What is a very common scenario is you've received, quote unquote, a longer term license or even a perpetual license, but that you're paying for ongoing support and maintenance. And what happens is that the provider of that support and maintenance is acquired by a larger entity, and all of a sudden you're paying triple what you were paying before. So having some awareness of these costs and these fees, et cetera, will be of great value to you, because when faced with a higher cost in a purchase situation like that, it's always great to know what your rights are and be able to take your business elsewhere, because telling a new purchaser that's telling you need to pay extra that you're just simply going to move to a different provider is often the best leverage that you have.
I'm really glad you asked that question. Building off what AJ said, is that if I was to pick one of these legal boilerplate lists to pick that addresses that, and is also often the most important and hotly negotiated one, it's assignment or a change of control. What's usually just a typical, prior notice or mutual agreement type of provision can become very complex in IT procurement, specifically because of the scenario you described. You should be on the lookout for what, a lot of reviews will just skip over, is assuming there's standard language in there. Well, that can actually signal to you the situation of your vendor within their industry. If they're looking for a lot of latitude to reassign this agreement as a part of a mergers and as acquisitions, I can speak from personal experience that we negotiated with a vendor that sold their company literally the month later. And the reason that the assignment provision was the biggest part of the agreement and the hottest, most heavily negotiated component is because they knew that it was going to come into play immediately. So assignment is important. Some strategies for that really quickly are making sure that you get the notification, but also if you can't necessarily force a prior approval right, which is sometimes, especially for startups, next to impossible to secure, getting a right to terminate separate from your other termination rights built into that provision can be very helpful, because then you at least get the opportunity to evaluate this new face that you didn't contract with before and see whether or not they can meet your needs in the same way.
Excellent. Well, AJ, the students seem to be doing quite impressively well, thanks to some phenomenal teaching. Allison and Chris, great job today. I think this is your first presentation that either of you have done. Is that correct? Second for Chris. Anyway, you guys are terrific. AJ, great job. Thanks to all of our speakers, and thanks to all of you for attending. We hope to see you back here next month. Thank you very much.